Hello everyone, I'm Leonard French, your favorite copyright attorney, and thank you for joining me this Sunday morning, my Sunday morning. It might be your Sunday afternoon or evening, and I think for a few of you it might even be Monday, but either way, this is still the Sunday morning live stream, the Lawful Masses with Leonard French show. Thank you very much for joining me. Joining me in the studio live here is Brandon, Yosho Man, Captain Yosho. Go ahead, Brandon, say hi if you're here.
Hello.
Everybody let me know if the audio is synced to the video, if my microphone level is good enough. It might clip a little bit if I get real loud. I haven't quite set all my settings right, but what I do think I did fix my the hum that I had in the low end. I think I had some kind of I don't know, either line noise or you were catching my fans from my PC or something. So I put a low cut filter in there, and I have some socks actually underneath the tripod for my camera. So we'll see if we're getting a little less noise there. So great, thank you. I'm hearing from everyone that the audio is good. Great. So, yeah, that was kind of a Freudian slip there, wasn't that? So it might clip a little bit if we have more NFL arbitration stories. Yes, Aaron, yes, it might clip a little if we get into more NFL stories. Actually, it's turned up from the NFL stories, so we'll see what's... Don't keep your fans in your PC, says James. Thank you very much. That's kidnapping. I appreciate it. All the laughs. So we have a bunch of interesting stories today, and as usual, I am about half prepared for all of this, so you're going to get to see some of the cracks and gaps as we switch scenes and try to get everything incorporated here, but we'll get through it together. And then I also want to remind everybody that there are 2 patrons-only live streams today. I am trying something new. I am producing a sponsored video for one of my Patreons. New Sensei sponsored the Basics of Copyright for Content Creators video. And we think it might be the beginning of a series or something like that. So I started producing it, and I wrote an agenda, an outline, started producing it, got through most of it, was editing it, and absolutely just hated it for some reason. Wasn't satisfied with it at all. So I came up with something that might satisfy me. I scheduled 2 live streams with the patrons, and there's still time to become a patron if you want to participate. Becoming a patron is only $1 or $2 or something like that. I don't even think... Anyway, well, you could probably, become a patron and then cancel it if you really don't want to pay the $2. But anyway, if you want to participate in the patron stream, be happy to help you do that. The streams will be like a kind of live studio audience thing for the recording of that Basics of Copyright for YouTubers or for content creators video. And so the idea would be I'll run through my performance and whatever a discussion of that of those issues and that topic, and then edit down to the final product from that original source. So we'll do that twice, see how it goes. I scheduled it twice, one at 1 p.m. today Eastern Time US and one at 7 p.m. Eastern Time US, so that people could make it from whichever part of the world or time that was best for them. That was based on a poll that I did of the patrons, so if you want to be involved in that next time, be a patron and you'll get notice of that poll and can help participate in scheduling and all that. So, Noogitron has a question. Brandon, if you could help Noogitron ask his question so I can queue that up for later. I'm going to try to get through all this material without taking 2 hours this time.
Yeah, of course. Just send the link, so...
As to those 2 shows at 1 and 7 p.m., the patrons will be able to ask questions by text and by voice live on the show, and then those questions and everything, including their voice questions and my voice answers and everything, will be part of that final edited episode of the Basics of Copyright for Content Creators.
So for the patrons, I'll share the link to the Discord in the patrons channel. Is this stream going to be public for people to watch, or is it only for patrons to watch?
Those streams will be unlisted, and so if you manage to figure out how to get a hold of the link, you can watch, but the participation will be limited to patrons only, and my intent is not to make it a public thing that I'm recording these. It's not for the general public to watch. This is an insiders only kind of thing, and since making it a private stream is not possible without inviting all several hundred of the patrons, I don't even know how I would do that easily. We just make it an unlisted thing and then publish it only to the patrons' channels. So that's what that is. If somehow the patron stream got inundated and there were hundreds of people, whatever, that'd be fine. I mean, I'm still limiting the questions and the participation to the patrons.
Yeah, we're just sharing.
And it's meant for the patrons. We're trying not to make it a public thing, is basically what it is. Of course, I'm discussing it here in public because I want you to become patrons and then participate that way. But I don't care if somebody gets the link and watches the stream, but it's not intended to be a public thing. So, the first thing that I thought we should discuss this week, the big topic of the week, of course, was the PewDiePie Firewatch controversy. Sorry, let me put this on shuffle real quick before I forget and the music ends. So the PewDiePie Firewatch controversy is over, more or less, but the discussion or the consequences from it really aren't over, because this really threw everybody for a loop. This invalidated some of our assumptions about the DMCA, what it could be used for, what people could get away with. And this is the, I guess, first time that we've seen a developer use a DMCA successfully against someone more than capable of defending themselves, solely because that person said something they don't like outside of the realm of their relationship with that person. I don't know, I would call it privity, but that's a kind of a stupid, archaic word. But that Firewatch developer and their relationship with PewDiePie had almost nothing to do with that stupid thing he said on stream. And you could really argue both ways, that it either brought more attention to issues in a good way, or it brought more attention to things in a bad way. It really was just kind of like a separate issue, a separate thing. Like the Venn diagram overlaps, but it really was like its own separate entity. And so that was really weird. So what has happened, what we know since the last time we talked about this a week ago, is that the strike did go through. PewDiePie originally pulled his own video, made it private, so the video link would still have been up, but it was set to private, and that still got a strike, or still got a DMCA claim, and that DMCA claim still went through as a strike. So I think he said he's going to let sleeping dogs lie and let that strike just stay and let it expire in whatever 90 days or whatever he's whatever, however that works. I don't even remember what the exact number of days is. And all I can think of is what a terrible misuse of the DMCA. This might be the technical way the process plays out. If you think about it for a moment, there's a lot of tabloid-style hyperbole being thrown around that DMCA can be abused by anybody now. This is a slippery slope, etc. And I agree. However, those things would be the result more of learning this information and not any change in the actual way the process works. So YouTube has to stay in their safe harbor in order to be free from any claims of hosting copyright infringing material. So in order for YouTube to stay within their safe harbor, they have to comply with the DMCA. So this could just be a result of YouTube technically complying with the DMCA. Firewatch Dev made a claim. YouTube is not the body that adjudicates claims. They are simply the recipient of the DMCA and the content host. So they would pass the DMCA on, take the content down, allow for a counter notification. if PewDiePie doesn't fight it with a counter notification, then wouldn't YouTube issue the strike like normal? So this really sounds to me like it's just the normal way this scenario plays out. And it's just a really crappy way that Firewatch, Camposanto, whatever his name is, Sal Vanneman or whatever, Saul, somebody remind me, it's just a really crappy way for him to use the DMCA. It sends a message, sure, and people have protested by kneeling for football games during the national anthem. People have protested by fighting each other in the streets. There's all kinds of different ways people protest each other. They're not always right. This is a new way we see copyright being used as a protest. Sean, thank you. That's why I wanted to say S. Sean Vanneman. The songs are listed. They're probably hard to see in anything less than 1080p. You do hear Windows sounds. You're playing my desktop audio, and so you actually are getting whatever plays on my desktop. Mini Vanneman.
Saul Vanneman.
Saul Van. All I could think of was Better Call Saul. Sugary coffee.
Good stuff.
So does this jeopardize, my next question is, does this jeopardize YouTube's safe harbor? Could someone successfully sue them for allowing a strike when the content was completely authorized? And I think not yet. I think you have to show that YouTube somehow had some knowledge or something, and instead they can just have plausible deniability by just technically following the process in a very dry and unadjudicative way. Dale, thank you for the information. I can understand why lower quality would not be synced. I am currently broadcasting at 4,500 kilobits per second, so it's possible that anyone with a lower bit rate on their stream would have to be processed by YouTube first, and that could definitely throw it off. I'm still working on getting everything perfect for the streaming rig here, but Bill, there will be updates in the Imagos case. Stick with us for another day or so, and I should have a full update round about Monday or Tuesday at the latest. Slight desync on 1080p. If you can tell me which direction it is, I can try adjusting it. The last time we had to add a 66 millisecond offset, which I just did again, and you can tell me if that helps or not. So keep an ear out for that, Jerry. So what do we think about the PewDiePie situation? Any feedback from chat? Let me mute my microphone while I snort. You
muted your microphone for the stream, but not for me.
A different microphone, yes.
Sorry, it was wonderful. Anyway.
Cardo, I hope that's how that works, but after 2 years of doing this, I have seen the AV offset or the thing be out of sync for a couple different reasons. It does definitely have to do with time sync and time encoding and all that, and me too, Karos, but we're not talking about that. Thank you very much. All right, any word on John Oliver's shenanigans? Jinzo wants me to do a line of Coke. I'll tell you what, how about some IBC cream soda here? And no, I'm not sponsored by IBC. I just like IBC cream soda. I like H-Treat cream soda.
So good.
I like my Appalachian Brewing Company. The reason I'm calling all these out are these are sugary drinks that don't use high fructose corn syrup, and they're all in the specialty drink section of your local grocer. And it bothers me that they could be removed at any time because I don't like high fructose corn syrup or caffeine. I'm not like pretentious or anything. Those things are fine. I just don't find high fructose corn syrup to be healthy for me. And I have migraine headaches, and literally when I cut certain things out of my diet, I find that I don't get as many migraines, and that's one of the things. So sorry. And I find sugar tastes better than high fructose corn syrup anyway. And caffeine is just... I'm already hyper enough sometimes. I'm already get worked up enough sometimes. I really don't need any more caffeine.
So if IBC wants to reach out to us...
Well, it's more ABC. I like the Appalachian Brewing Company's root beer. I buy about 2 or 3 cases of that a month.
Nice.
A-Treat isn't out. I just don't drink as much of it because A-Treat does have high fructose corn syrup. Bars cream soda made in Scotland sounds amazing. I'll be happy to look that up. Sugar will rot my teeth, and so I do go to the dentist. I do floss my teeth every day. I do brush my teeth every day. And so far, they're okay. Those are my natural teeth. Mostly the damage is from I chew my nails, so don't chew your nails if you want your teeth to look better. I did smoke a little bit when I was younger too, so my teeth are a little bit yellow. Anyway, so fluoride rinse. Now that I'm all self-conscious about my teeth, thank you very much. Let's see. Oh yes, and I am a typical American because I'm not going to forget I have a worldwide audience here. Of course, my parents wanted my teeth fixed, as well. So I don't know. I may have needed my teeth fixed. I'm not sure. I had, actually, believe it or not, I had 6 wisdom teeth that had to be removed. So maybe they would have become impacted and affected the rest of my teeth, and I would have had a horrible whatever. So maybe we do need lots of cosmetic dentistry in the US, but it is a little weird that, like, everybody gets their teeth fixed as a cosmetic thing, even when it's not a medical thing. Anyway. Brandon, talk to Dr. Weeble and see if you can get him the mailing address, if you don't mind. All right. Someone wants a Hughes and Benjamin update. Someone wants a Sargon update. I will be looking into both of those this week. I don't have anything prepared for this morning. Yes, they said I was 1 in 11 million is the chance of getting 6 wisdom teeth. Okay, so the second story that I wanted to talk about, and we'll see if I can bring up a story here. Do we have a link for this, Brandon, on the Pepe the Frog thing?
I don't have a link, no.
Okay, let me find a link real quick. I've been talking long enough that all of my tabs reset them. They all suspended themselves, so I got to go through them one by one. Here we go. Let's see if Firefox is still working here. Firefox, there we go. Okay, so here's an article on care2.com. Pepe the Frog creator will donate book profits to American Muslim group. The creator of Pepe the Frog sued or made some kind of claim against a book author who had used his book used Pepe the Frog, used his character in his book in the unauthorized book without the original creator's permission. And since the creator did not like the use of this particular book, it was a pretty much anti-Islamic, white nationalist supporting book, the book author, what's his name here? Not Matt Fury. Matt Fury is the original creator, so he's the one making the claim. I don't see the other guy's name, but the unauthorized copy will be pulled from sale, and any profits from its sale will be donated to Muslim American relation groups, which I think is a great and very interesting use of copyright. So what this implicates, you may know that in trademark, if you don't protect your trademark, you lose it. Well, in copyright, you don't. It's not the way it works. You can allow people to infringe on your copyright, and heck, we see that every day. If you can accept my premise that Let's Plays are somewhat automatically copyright infringement and then have to find a way to be not copyright infringement, then Let's Plays are potentially some kind of copyright infringement, and that happens all day, every day. Excuse me. So why doesn't everybody get every stream taken down? Well, many developers and publishers recognize that Let's Plays are a sales channel, or a marketing channel, that we the communities are freely marketing for them by saying, hey, this is a good game, hey, this is a good game. And then the only people who really hate that are the people who are trying to market a not so good game, because then we notice that and we say, hey, don't buy this game. So you actually see the James Romines and such of the world trying to take down the critics when they aren't favorable. But when the critics are favorable, then it's a great marketing channel. I mean, I just bought Divinity Original Sin 2 last night, and I would not have bought it without watching videos on it on YouTube first, and not just marketing videos. Actually, here's the thing, guys. If anybody here is a content creator or developer, I mean, like publisher, those videos you put on Steam that like show how you rendered your game at E3 or whatever, they don't make any sense to me. I can't decide to buy your game off of the videos and pictures you put on Steam. I have almost never bought a game based off of the pictures and videos I've seen on Steam. I have to go to YouTube to see relevant gameplay. So could we please have some gameplay videos on the Steam in your gallery there with all of your stuff? Okay, I'll get off my high horse. Anyway, so the point is, they can allow these Let's Plays to be published and created and all that, and everyone can benefit or not benefit from that. But like we just found out this week in the PewDiePie scenario, a developer can pick and choose when they want to take something down. Now the jury is out, not literally, on whether or not Firewatch devs' use of the DMCA against PewDiePie was actually proper. That fight is not going to be adjudicated, so we do not know for sure whether a judge would say or a jury would find that that use was improper. So that doesn't fix the situation. But in theory, in concept, if you are a content creator and you see someone using your material, or you see 100 people using your material, why is that doing that? Why am I getting a notice for every new... That didn't used to happen. Anyway, if you are a content creator and you notice someone using your material in a way you don't like, you can pick and choose to take down that material. If you have a streaming policy that says everyone can stream, then you might want to address that first. Recently, we went over a game developer's streaming policy that had conditions in it and said you can stream as long as you are not racist, homophobic, etc., 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 and had other very reasonable conditions in there. And I think I'm going to make a video about that particular developer and their policy, because that was a really well-written policy, and I commend the legal or not legal team, whoever figured out how to write that policy. I approve. You've got the approval of lettered French. Okay, so oh, his name was Eric Hauser. He's an assistant middle school principal in Texas, and he's the one who wrote the children's book called The Adventures of Pepe and Pede. The story features Pepe and employs white nationalist themes. That's what that was all about. Okay, so here's one that I haven't quite gotten a whole lot prepared on, but we'll look at the complaint. The Gab AI app versus Google. Somebody try to bring me up to speed on this. I don't know if Brandon, if you know anything about this, or if anyone on stream knows anything about this, but it seems like this company got pulled off of the Google Play Store. And of course, you know, how else do you get into the market if you aren't on the Apple Store or the Google Play Store? So that's kind of that's going to make that difficult for them. So let's take a look.
I have a complaint.
You have a complaint? Go ahead.
It's in the agenda.
Okay, 1 sec. No, it's the 701. It's on my website.
All right.
It's on leonardjfrench.com. It'll even say on the contact page what's for USPS and what's for FedEx and UPS. Okay? That's not a complaint, by the way.
Shoot.
That's just a what's your address?
No. The complaint
where
is
am
on
I?
the Gab thing.
Oh.
Yeah.
Oh, you have the complaint.
Sorry,
okay.
I have
I'm sorry. I thought you meant we had
Gab.
like a complaint, like something was wrong with the stream or something.
No.
Okay, where is... There we go. Okay, so here is the complaint. We're really well prepared here today, folks.
Should I research the other ones too?
Well, that's going to be... I'm going to be asking you to make that your job in the future, but I've been so disorganized this past week that I'm so glad I have this whole next week to get reorganized again. Okay, so this is a very long complaint, so we are going to power through this very quickly. So Gab AI is the company that is suing Google, right? I don't care about jurisdiction and venue. So Gab is a social network at gab.ai. Twitter ran into controversy when it was accused of censoring conservative voices. In light of these developments, they saw a market opportunity for a competitor focused on free speech. So it's a free speech Twitter competitor. Okay. Some guy was barred from Y Combinator's website. Which confirmed his perception that conservative voices are routinely suppressed in social media. So Gab is superficially similar to Twitter, 300 character limit, etc. They've also launched Gab TV. They empower creators. Remember, these are all plaintiffs' claims. It doesn't mean these things are actually true. It just means they're claiming them to be true. Gab follows the U.S. Department of State's definition of terrorism and lists of foreign terrorist organizations, etc., etc., etc. Gab differs significantly from leading social media platforms such as Twitter, Facebook, Google, and others, which have made the elimination of hate speech within their realms a publicly prominent priority. Say that 4 times fast. Publicly prominent priority, publicly prominent priority, publicly prominent priority, publicly prominent priority. There we go, got through it. For this reason, some unpopular and even offensive but lawful points of view have been effectively muted or banned from platforms such as Twitter or Facebook, and those people use Gab. Okay. Okay, so they allow blocking. It's an advertising-free service. They do not monetize information. They're supported by donations. They hit 1 million in Title III crowdfunding. App stores. 2 main distribution channels. Apple's App Store, Google Play Store. What else? There's nothing else. Microsoft, what did you do? You were bad, Microsoft. You had a good operating system, but you could not get it out there. 99.6%. Yep, that's about right? So Gab was never permitted to offer its mobile app for iOS and the Apple App Store. Apple's initial stated reason was for its distribution of pornography, which was baseless. Apple subsequently rationalized its refusal to permit iOS users. After each submission by Gab to Apple, a revised build of the Gab app, Apple acknowledged Gab's compliance within 1 or 2 days. So Gab is, I guess, now on the Apple Store. Following Gab's resolution of the last of the series of technical compliance, Apple delayed 17 days until rejecting Gab on a new ground that posts by users could be considered defamatory or mean-spirited, including comments based on ethnicity, gender, or other groups. Apple obtained this content by going to Gab's desktop sites and searching for specific hate speech terms. Apple informed Gab that if Gab would remove all defamatory and mean-spirited content from its app, Apple would reconsider its rejection. It is, however, impossible for any social media platform that has 250,000 users to remove all defamatory and mean-spirited content, much less to prevent such content from being posted prospectively forever. Okay, so that's Apple, but you didn't sue Apple. You sued Google. Apple rejected the Gab app on the ground that Gab was a social news app with mean-spirited content on January 21st, the day after the inauguration of Donald Trump. Okay, whatever. I'm not agreeing or disagreeing, I'm just saying, okay. You didn't sue them, though. At least not here. Unlike iOS, the Android operating system permits users to download apps other than through its App Store, and the practice is common, although no statistics are available to establish the percentage of apps downloaded outside the Play Store. The practice of downloading Android apps outside the Play Store requires bypassing security options on Android devices and is intimidating to many users. Okay. We'll go over that later. Lots and lots and lots about Google. Here we go. The foregoing description of one aspect of Google's market influence is just one example of Google's ability to use its cross-platform dominance. That market power, which amounts to monopoly power in many respects. Oh, you know what? I think I have to turn off my system notifications. I think that's what it is. System sounds are muted. Let's see if that does it now.
Check, check. Can you hear me?
I can hear you. Can you hear me? So more about Google. I really think, here we go. Gab. Gab was approved and became available for download in May of 2017 in the Google Android Play Store. Following its placement, Gab's download and the number of Pro memberships surged. Gab's rollout in the Play Store and the significance that signaled to the market as its viability as a business also led to an increase in donations and support. On August 17th, Google Play notified Gab that Gab's Android app is being suspended and removed from Google Play as a policy strike because it violates the hate speech policy. Moreover, because Gab is not itself a content creator but is instead a social network, the reference to hate speech in the notice could only refer to content posted by third parties, i.e. users. Indeed, in a subsequent email to Ars Technica, Google explained as follows. In order to be on the Play Store, social networking apps need to demonstrate a sufficient level of moderation, including for content that encourages violence and advocates hate against groups of people. This is a long-standing rule and clearly stated in our developer policies. The entirety of Google Play's hate speech policy set forth in its Developer Policy Center, however, simply reads, hate speech, we don't allow apps that advocate against groups of people based on their race or ethnic origin, religion, disability, gender, age, nationality, veteran status, sexual orientation, or gender identity. There is no reference to moderation. Indeed, there is no definition of what exactly constitutes sufficient levels of moderation anywhere in the Google Play Development Policy Center. Rather, Google's policy concerning user-generated content states only that apps UGC, I think that's a typo, that UGC-oriented apps must take additional precautions in order to provide a policy-compliant app experience, requiring apps to define and prohibit objectionable content via terms of service, implement a system to report content, and block users. Gab meets all of those requirements as set forth above. Okay, so let's see what their counts are. They're going all out here. I kind of get it. I'll get to that in a moment. So they have filed for relief under the Sherman Act, claiming that Google is a monopoly and they are misusing their market power. Then they are claiming a violation of the Clayton Act for unfair dealing, an unfair and exclusive dealing. Google's conduct, as alleged above, amounts to an unlawful accretion of economic power, concentration, monopoly, or oligopoly in the market for mobile social news apps. Google's conduct has created conditions in the market for social news apps that encourage the creation of parallel policies of mutual advantage. So they're saying the parallel policies between entities, third-party entities, and insider entities of Google's, of Alphabet's, basically. Tortious interference with prospective economic advantage would be that Google's removing them from the Play Store is an interference with their ability to make money. All of that sounds good. I probably would have also included some kind of breach of contract claim or something for the breach of their own policy. They're not applying their own internal policies equally to... You can have internal policies. They can have all of those policies, but they have to be applied equally. So that is a very interesting lawsuit. Oh! Didn't even expect to see this. It has been filed by none other than Jordan Rushy of the Randazza Legal Group, a former BitTorrent defense attorney that I have used to work with and currently have a live case against. That's interesting. So hi, Jordan, if you're watching. Love you much. You know what? And now, you know what? I thought something about this sounded familiar. I really couldn't place a finger on it till I saw that, and now I recognize the writing a little bit better. And this is exactly the kind of thing I think that Jordan and Randazza would do. And there's nothing wrong with that. I just mean that's their thing. Is their free speech, their First Amendment attorneys. So I have nothing more to say about that. Any questions? Okay. If you have any other questions and I didn't get to them right now, you can send them to Jordan. Wow. Brandon through the link that he's going to post in the chat.
Yes, of course.
All right, only 40 minutes in. Woo, we're doing good.
I cannot find any complaints on the Chris Farley case, just so you know. I can only find a filing.
I have the Farley
okay,
complaint.
Cool.
I have the NBA 2K complaint.
Okay.
Those are the only ones that we're going over. We're not going over the others.
Okay.
So the next one is only in the news recently. It is not a recent thing that has happened, but rather it is just a recent protest that has happened. And so the thing that's in the news is that the Juggalos, the insane clown posse fans who organize themselves loosely as the Juggalos, were in 2011 classified as a loosely organized hybrid gang, and they are protesting that or what we're protesting that with the FBI, or against the FBI in Washington, D.C. very recently. In 2011, the FBI put out this report. And if I could... Why can't I search? I have lost my ability to search. Thank you so much. Share this page. No, why can't I search this page? Because it's just a lot here. There's a whole bunch of stuff listed here. I gotta do a search for Juggalos. Find here. Yeah, something's not working. Anyway, oh, it's at the bottom. That's why I can't find it. Okay, so Juggalos, a loosely organized hybrid gang, are rapidly expanding in many U.S. communities. Although recognized as a gang in only 4 states, Juggalo subsets exhibit gang-like behavior and engage in criminal activity and violence. Law enforcement officials in at least 21 states have identified criminal Juggalo subsets, according to NGIC reporting. Juggalo gangs are expanding in New Mexico primarily because they are attracted to the tribal and cultural traditions of the Native Americans. Most crimes committed by Juggalos are sporadic, disorganized, individualistic, and often involve simple assault, personal drug use and possession, petty theft, and vandalism. However, open source reporting suggests that a small number of Juggalos are forming more organized subsets and engaging in more gang-like criminal activities such as felony assaults, thefts, robberies, and drug sales. Social networking websites are popular conveyance for Juggalo subculture to communicate and expand. Does anyone actually believe this? Like, for real? I mean, chat, help me out here. Like, I've definitely seen videos of people who claim to be Juggalos or Insane Clown Posse fans doing things that could be considered criminal, but it's all, like, pretty minor crap, right? It's all, like, what they just described. Like, disorganized, individualistic, personal drug use, simple assault, petty theft, vandalism. How in the world is this a loosely organized hybrid gang? And do they really deserve to be classified like that as a whole? That's weird to me. Like, I'm not a Juggalo. Like, I actually don't like the music and I don't really like the fans, but I don't think they have to be classified as a gang. And that just sounds weird, right? I mean, and definitely there's, like, stupid little gang things people do, but, like, that could be anybody's fans. I don't expect it to be, like, Taylor Swift's fans, but, you know, there are gonna be people who listen to harder music than Taylor Swift, and who knows if... It doesn't... I don't think it's because of the music. I think they're just coming to finding each other because they like the music together. And then pockets of people are doing stupid shit. Correlation does not equal causation, right? Like, I guess I would have to hear more. Just those paragraphs from a 2011 gang assessment really don't convince me that they really are a gang. And so what are the consequences? The consequences are these people lose their jobs, they can't get jobs, they're denied basic participation in parts of society that can look up and see on their Facebook page that they like the Insane Clown Posse, and then automatically these people assume that anyone who likes the Insane Clown Posse or calls themselves a Juggalo must be part of a gang, and therefore gangs are bad, and we get to do the hating right back on the gang. That just sounds like more of, if you do this, you're gonna screw up your life. So to prove it, we're gonna screw up your life. So let's just say that this was successful. Let's say that there wasn't economy and there wasn't, you know, ups and downs and 4 million factors and such. If the FBI puts out this report in 2011, and let's say all Juggalos immediately lose all economic prosperity, that puts them into the situation where they're more susceptible to becoming a gang. And now they have a common enemy. The FBI, who has chosen to single them out as a gang and destroy their ability to achieve economic prosperity. That sounds dangerously close to a self-fulfilling prophecy. I'm really concerned about that, actually. And I'm honestly a pro FBI guy. Again, the FBI helped me, or I helped the FBI, or maybe they just did it without me. I don't know. But I spoke to and reported to, interviewed with the FBI, and have followed up with the FBI, who have helped me take down a child abuse sex offender who got away with it and had access to many thousands of boys over many, many years. And the FBI actually drove to a victim's house in the middle of a blizzard, 6 hours away, probably more like 10 in the middle of a blizzard, because it was that important to them to talk to the victim so they could move on the allegations. It makes me emotional because they did that. So let's not get too down on the FBI for making a mistake, but let's acknowledge that they might have made a mistake here. Without more, I do not see the Juggalos as a gang, as being worthy of being labeled a gang. Even a loosely organized hybrid gang is not going to be wording enough, disqualifying language enough to prevent people from being hyperbolic about the use of the word gang and the association with the Insane Clown Posse. And I'm even concerned about gang activity. I agree that we don't want gang activity, like that kind of thing. Certainly people should have the freedom to associate, but not associate and correlate, with we're not just, or have more than a correlation with violence. Associate and cause violence is basically what I'm getting at, I guess. So, I don't know. That one, I could see both sides of that one. That's a really difficult situation. So great, we have another. How do I turn this off? Why is this doing this every time?
You're still getting the boings from the email?
Yes, I'm getting my normal. Can I just turn off Windows notifications at all?
You can do it from the volume mixer on the bottom right. Did you try that?
I did, though. I did turn it off. It's still doing it. Turn on quiet hours. There we go. I'm turning on quiet hours.
Quiet hours from 1 a.m. until 12 a.m.
No, it just says it's the action center. I'm just turning on quiet hours. Maybe I don't know. Maybe that does it.
Do it.
Tao is going to tell me. Yeah, yes. Hey, there you go.
There you go.
Meanwhile, the Bloodhound Gang isn't classified. Okay, dog break. Hey, everybody, we're going to do a dog break right now. What do you think?
You can't mute the channel in the mixer, Keith, because that's the channel that I'm coming through and the music. So.
Hello, honey. Would you like to say hi to the stream? How are you? We were debating just doing 2 hours of petting the dog this morning. But then he got down. All on his own. This is Nico, if you don't know Nico, if you're joining us for the first time. And Nico is my 2-year-old golden retriever. I own dogs because I don't have kids. To have kids, I would need to have a stable relationship. And that hasn't happened yet, so while I'm waiting for that, I fulfilled my my middle-aged man need for a child by buying dogs. So they have been a blessing. It has been awesome. When I had dogs when I was a kid, we did not use the positive reinforcement method of training. And I would highly recommend that someone read The Monks of New Skeet, S-K-E-T-E, New Skeet, New York. I highly recommend you read that book, or Cesar Millan's book, or any other book on positive reinforcement, because it turns out that doggy brains are very much like little child brains, like human child brains. And when you treat them like people, I don't mean that that they have to be accommodated like people. I just mean that if you treat them emotionally like people, if you're supportive, if you are careful about when you yell at them, when you punish them, if you're careful not to hit them or otherwise traumatize them, they actually grow up like really, really, really healthy little people. And they actually sort of know wrong from right, and they know your mood, and they really are the most supportive little beings. And I can see the man's best friend thing now. When I was raised, you waited for the dog to do something bad, and then you smacked it. And that's a horrible, horrifying thought to me these days, because I've never had to smack these guys. I've never had to get physical almost at all with them. Ilsa a little bit. Ilsa's a very strong, very dominant German Shepherd, and I'll admit a couple times I've had to grab her, but I've never had to hit her. Occasionally she's had to use like an electric collar or an electric fence, but just to get the message across that she really can't go jump over the fence and go to the neighbor's yard or the dog or whatever. But that's just because Ilsa is an extraordinarily dominant German Shepherd dog. This guy has needed none of those kinds of negative corrections, and instead just needs positive reinforcement. And he is one of the nicest, best dogs I've ever known. So I highly, highly, highly recommend, if you're going to get a dog, that you learn about positive reinforcement. If you can't get a book, if you're not going to read a book or whatever, at least make sure that you socialize the dog and that you learn about being positive with your training instead of negative. Yes, Nico is fixed. It was a very hard decision. I cried. It's a very hard every time. It's very, very hard. Yes, the sound is extremely out of sync. This camera is not synced to this microphone. Sorry. I would actually have to adjust the camera sync, and I don't even know how to do that. Nico is looking at himself on the preview. That's what he's doing. Alright, I'll leave him here, but I'm going to continue with the show. He will get down on his own in a moment. Especially after his stretch. Okay, so real quick update with the Macaque selfie. Yeah, we'll just leave this here. So I apologize for the sync, but bear with me. The sync is just because we're on the dog cam. I could also adjust the dog cam a little lower, then you won't even see me out of sync. How about that? Haha. So the Macaque selfie, the monkey selfie, it's not a monkey, but everybody calls it the monkey selfie case. The Macaque selfie case is over. There is no legal precedent set here. A deal was reached between the person who has been publishing the picture and PETA, and I believe that person who was publishing it was the photographer. The deal means that the photographer will donate 25% of future revenue from the image to charities that are dedicated to protecting the macaques of Indonesia. And that's it. Case over. So I don't think it was a very strong case on PETA's side, so the fact that PETA got 25% donated to Indonesia to macaque protection, great. I still question the value of that organization, but whatever. The case presented some very settled points of copyright law that would at least be interesting to hear a judge rule on. So I'm disappointed that we didn't get a ruling on that, but oh well. So let me know if you let me know if you have any comments on that. All right, and then you have two more, but two big ones though. So two big stories to go. The next one, it turns out that Trek Bicycles is getting sued for copyright infringement or likeness infringement. What do you think Trek Bicycles might be getting sued for regarding intellectual property rights infringement? Well, it turns out that Trek Bicycle has a whole line of fat tire bicycles that are called the Farley. And, well, there's a certain performer, very, very famous and beloved comedy performer, who, well, he was a pretty large individual too. And so he, not he, because he is past, The owners of Chris Farley's intellectual property have sued Trek Bicycle, claiming that they unfairly profited off of his off of the likeness. And so here is the complaint. Oh, you're gonna make me move the dog cam, aren't you? There's the dog cam. Oh, you got both. You got me and you got the dog cam. What lucky people you are.
Wow. Dang. We are a multi-camera stream now.
So this is the complaint. In the Superior Court, State of California, County of Los Angeles, Make Him Smile, a California corporation, demand for jury trial versus Trek Bicycle Corporation for common law misappropriation, violation of civil code, false endorsement, and unfair business practices. Plaintiff is a California corporation. Defendant Trek Bicycle, Wisconsin Corporation. Includes Doe's 1 to 1,000.
Oh my lord.
Plaintiff is informed and believes and alleges that each defendant was at all times jointly, severally, or vicariously liable for the acts of all other defendants. Common factual allegations. Defendant Trek Bicycle is one of the world's 5 largest bicycle manufacturers, and the largest manufacturer in North America. Defendant Trek designs, builds, sells, etc., authorizes third parties, etc. to build bikes. Defendant has fat bikes. Defendant has fat bikes with components to make them more agile and adept at traversing unpaved terrains. Have a wider than average chassis and extraordinarily fat tires, giving them a unique, eye-catching, and fat appearance. On its fat bike products, Defendant Trek prominently features the name and brand Farley. Plaintiff is the legal successor in interest, as such term as defined in California law, to the estate of and property rights formerly owned by Chris Farley. Farley died in 1997 at age 33, was a native of Madison, Wisconsin. Oh wow, so that I didn't even know that part. He is a world-famous comedy comedian and actor, best known for his portrayal of fat and loud characters on Saturday Night Live, and in films such as Tommy Boy, Black Sheep, Beverly Hills Ninja, and Almost Heroes. At the time of his death, he was domiciled in the county of Los Angeles. Oop, honey, don't fall. Prior to his death, Farley's IP rights acquired tremendous commercial value due in part to Farley's name and one-of-a-kind celebrity and persona. Farley's name, identity, and persona are instantly recognized by the general public throughout the world and have substantial commercial value due to Farley's carefully crafting his identity as a comedian when he was alive. For the entirety of his adult life, Farley was overweight. When he died in 1997, he was 5'9" and weighed 400 pounds. He spent his entire career building and capitalizing on his unique brand of fat guy humor and acting style. He developed a very powerful brand recognized by millions. This brand is embodied by the Farley IP in various forms, Farley's brand of comedy and acting, and his significant and unique celebrity status. The name Farley is now, and has been for nearly 3 decades, linked and associated with his persona and identity as a fat comic actor willing to go into comic territories others would not seek to traverse. See what they did there? He's going into territories the fat bike goes into territories that others would not seek to traverse. Wow. And yes, if you remember Chris Farley, you are now old.
Oh my god, I'm old?
Yes, we are all old. Not if you remember, but in 1997, I was 17 years old. So, I remember, seeing his person on the screen. So if you were old enough to remember that at that time, then you're old now, because you're at least 25 years old, and that's old, right? If you don't think a 25-year-old is old, have a 25-year-old walk into a high school. Trust me, 25 is old.
We do not recommend this.
Not without permission to walk into the high school. I'm not encouraging anyone set off the intruder alarms at the high school. Okay, so that we know what that's about now. So they think that Trek Bicycles was capitalizing on the Farley name by making fat bikes. And there's going to be a lot of description of loud, fat, Midwestern, and comparison to fat, loud, and wide bicycles in the Trek family. Okay, so that's interesting. There are a lot of Farley. There's the Farley 5, the Farley 7, the Farley 9, the Farley EX8, the Farley EX 9.8, the Farley 9.6, the Farley 9.8, the Farley 9.9, the Farley 24, the Farley carbon frame set, and the Farley alloy frame set. So this is not just some small one-off thing. They created a whole line of bicycles based on this, it looks like. So they've filed for first cause of action, common law misappropriation against all defendants. The name Farley and other elements of the Farley IP are readily identifiable. Any person can readily determine the Farley name on the bicycles. The misappropriation was for defendants' commercial advantage, etc. Violation of civil code. I'm not familiar with this particular California civil code. The acts of defendants were committed intentionally, maliciously, oppressively, in bad faith, and such that plaintiff is entitled to punitive damages. False endorsement. So that would be where you advertise using someone's likeness, name, or picture, or whatever, and they are not associated with it. False endorsement. And unlawful business practices. All under California law. So this is not even implicating any federal law here. This is just California law. So that's interesting. So Chris Farley, who quote-unquote always lived in a van down by the river, who we miss dearly, the allegation is that Trek Bicycles created an entire line of fat tire bicycles that use all of the same elements that Chris Farley's brand does as well. Fat, loud, Midwestern, goes where others don't, and they're comparing that to Trek's marketing campaign, which basically said the same things without actually making a connection to Chris Farley beyond using the name Farley. So who knows? I honestly don't know whether that's enough. So let's follow that one too. That sounds... Yeah. You're having a good time licking my pants there. Those pants only have the dirt from your paws on them. They're freshly cleaned. And maybe that's what you're licking, is the fabric softener. I don't know. I'm glad that's non-toxic. So then the last story that I have for today, before I take a break before the 1 p.m. patron stream, is that tattoo artists, or rather a copyright holder who bought the rights to artists' tattoos, is suing 2K Games for using those tattoos in their games, in the NBA 2017, I think, game. Are you having fun there, Nico? So this is Solid Oak Sketches versus 2K Games Visual Concepts Take-Two Interactive. And this is a memorandum of law in support of plaintiff against defendant's motion for judgment on the pleadings. So a judgment on the pleadings would mean that 2K Games or someone on defense's side said or made a motion to end the case early, claiming that there was nothing in the complaint. You want to get down? You're a good boy. You're a good boy. I love you so much. Okay. So that 2K Games, or that Solid Oak Sketches, that plaintiff's pleading, that their complaint is so lacking that there's nothing in the complaint that can be recognized as a legal cause of action. So let's take a slightly longer look at this. They're going to be talking about the background, a standard of review, their argument. They're going to be using fair use. They're going to say that the 4 fair use factors favor plaintiff, that defendants fail to allege that their use of the tattoos is de minimis. See, I always thought it was M-I-N-I-M-U-S, but I could be wrong. It could be. One of these is wrong. That's funny. And I'm not... Don't let me get down on anybody about their typos. I make typos all the time. There are typos in the Alex Mauer complaint, so it happens. De minimis simply means that the use of the copyright is so little that it is not a big deal. And so they're going to be saying that the use is not de minimis, that they're substantially using these tattoos, and that de minimis is not even an argument that should be concluded or adjudicated at this stage. So let's see what they have to say. Oh, let's see if we recognize... You know what? We're getting better at this. Let's see if we recognize any of these cases, guys. Ashcroft v. Iqbal. I think that's a jurisdiction case. Authors Guild v. Google was the Google book case. Bell Atlantic v. Twombly is a jurisdiction case. I don't recognize some of these. Campbell v. Acuff Rose Music is a famous copyright case. Carew v. Prince was another famous copyright case. Castle Rock Entertainment, famous copyright case. Dun and Bradstreet Software versus Grace Consulting. I want to say that was a famous copyright case. I don't remember what it was about yet, though. I think we went over it, though, on stream. Harper Row Publishing, we went over that on one of the streams. There's just so much to go over, guys. You could imagine how easy it could be for me to make to do the rest of my career going over all of this, trying to help everybody just keep up with copyright law. Plaintiff's sole motive for instituting this action is to be made whole for the infringement of its copyrights that it paid money for in exchange for exclusive licenses that it possesses. So keep that in mind here. We don't have the original tattoo artist suing. Rather, they sold their rights to the tattoos to this third party so that they could sue, which is normally okay, as long as it is a complete license. We do have cases, the Right Haven cases, that say that you can't just buy the right to sue. You have to buy all the copyrights. You have to have a complete license. You can't just license the right to sue. Plaintiff provided consideration, money, to various tattoo artists in exchange for the exclusive licenses to the copyrights containing the tattoo art at issue. That art was created by the tattoo artists and inked directly on NBA players Alec Bledsoe. You're gonna find out that I don't follow basketball right here. Eric Bledsoe, LeBron James, and Kenyon Martin, quote-unquote, the tattoos. Plaintiff paid for the binding and enforceable exclusive licenses for the purpose of exploiting those tattoos for commercial gain and to preclude third parties from infringing on plaintiff's exclusive right to do same. Defendants ask the court to construe the creation and enforcement of the licensing agreements as plaintiff simply being an opportunist. So they're saying the defendants are saying that plaintiff is simply an opportunist. They're saying, throw this case out, plaintiff is just being an opportunist. They saw this use and said, we gotta sue. If plaintiff's decision to enter into exclusive license agreements with the tattoo artists in attempt to create commercial opportunities is considered opportunism, then plaintiff is guilty as charged. However, there is nothing improper or illegal surrounding a company whose principal may have no experience as a tattoo artist entering into valid binding contractual agreements with tattoo artists for exclusive licenses over their intellectual property. Pardon me. Plaintiff received the exclusive licenses and then discovered that the defendants were illegally exploiting them in a manner that constitutes infringement. Plaintiff reached out to defendants prior to initiation of the instant action in good faith to explore the possibility of a resolution without court intervention. Ultimately, plaintiff was left with no choice. Plaintiff is not arguing that NBA players must seek plaintiff's permission every time they appear in public. Rather, plaintiff is arguing that corporate entities that purposefully seek to commercially benefit from the use of the tattoos be held accountable for their actions and pay a royalty to the rightful owner of the intellectual property. Here, defendants have sought to create as close of a replication to the tattoos within their highly respected video games, promote realism of the players to the consuming public, and avoid making any payment to plaintiff for the use of the copyrights in the process. Defendants' use of the tattoo is neither de minimis nor protected by fair use. Tattoos are a main design of the NBA players on which they are attached, and those players' tattoos are prominently featured, with LeBron James being the highest rated player in defendants' video game. Separately, the purpose and character of the use is clearly commercial in nature and not a matter of newsworthy or educational speech worthy of receiving an exception to laws concerning copyright infringement. Furthermore, the tattoos are used in their entirety, and plaintiff's ability to license the tattoos to third parties, including other video games manufacturers, is impeded by defendants' refusal to pay for the intellectual property that plaintiff is using. For the reasons set forth below, plaintiff respectfully requests that this court deny defendant's motion for judgment on the pleadings. So that's very, very interesting. If you have a tattoo inked on your body, and you then go on to license your body and likeness for use in a video game, and those tattoos get used in that video game, and those tattoos are reproduced accurately, is that an infringing use? Is that an infringement on the tattoo artist? That's a good question. That is a really, really fascinating question to me. So there's lots and lots of stuff in here. At the heart of the instant dispute is defendant's use of the tattoo, specifically whether it is considered de minimis or fair use, two separate things. In its brief, defendants contend that their use constitutes fair use on the following grounds. The tattoos are significantly reduced in size, users cannot see their expressive value, the tattoos only appear fleetingly and in small size, and defendants' use serves as historical or biographical anchors. Similarly, the de minimis claim proclaims that the tattoos are not prominent and appear smaller than they would appear in real life. To date, defendant has sent plaintiff many discovery requests, yet plaintiff has not been afforded the opportunity to conduct depositions or send similar discovery requests. Plaintiff intends to conduct reasonable discovery throughout the duration of this litigation. The fair use doctrine is an equitable rule of reason which permits courts to avoid rigid application of a copyright statute when, on occasion, it would stifle the creativity that the law is designed to foster. The applicability of the fair use doctrine is a mixed question of law and fact, and a court cannot engage in the fair use inquiry until it has been presented with facts relevant to evaluating the fair use factors. What they're saying here is that this is not the proper time to adjudicate whether or not it's a fair use. We have to get into discovery, and a motion for judgment on the pleadings means we haven't hit discovery yet. We have just closed the pleadings, and we have just entered discovery, and we do not have discovery responses yet. So what they're saying is that there are still facts to be uncovered, to be discovered, and there are also material facts which may be in dispute. Facts that are relevant to the case. Normally, facts that are relevant to the case must be discoverable, and can very rarely be kept out, and you'd be required to allow the parties to discover relevant material facts before making an adjudication. those parties, then that discovery means they get to ask each other questions. The parties, the opposing parties, have to ask each other questions, and those answers have to be made. And those answers can then be used against each other, but within rules. So we find out what the evidence is, and we find out if that evidence matters, and then we argue over whether that evidence should be admitted, and then we argue over how that evidence should be interpreted. So let's see what's in here. Hang on. I am losing. So they're going to argue here that a defendant is an appropriation artist, has taken plaintiff's copyrighted photographs and altered them to create crude and jarring collages. This was what Carew did. Both works had underlying artistic purposes, but the Second Circuit held that the work was transformative because the defendant's use was so heavily obscured and altered, it was barely recognizable. However, this one is not barely recognizable. In fact, they're going to argue that the tattoos were reproduced accurately and specifically. Far from altering the tattoos to the point where it is barely recognizable, defendants' use appears not to have altered the copyright at all. To the defendants, the video games may replicate how the players appear in real life, but it does not transform the original work so that it conveys that message. So they're arguing it's not transformative. The nature of the copyrighted work, well, obviously it's a commercial work. The tattoos are expressive or creative. The amount and substantiality, they're going to argue that they copied the entire tattoo accurately. And the effect of the use on the market. This evaluates the effect of the use upon the potential market for the copyrighted work. This factor requires courts to consider not only the extent of the market harm by the particular actions of the alleged infringer, but also whether unrestricted and widespread conduct of this sort engaged in by the defendant would result in substantially adverse impact to the potential market for the original. Although the Second Circuit places little weight on the loss of the licensing fee sought from defendants, fair use is usually disfavored where there is a showing of an impact of the potential licensing revenues for the traditional, reasonable, or likely to be developed markets. To negate fair use, one need only show that if the challenged use would become widespread, it would adversely affect the potential market for the copyrighted work. Impact on the market can be proven even without exploiting the market for derivative works or showing that the alleged use diminished the work's profitability. When conducting the analysis on the fourth fair use factor, courts are mindful that the more transformative the secondary use, the less likelihood that the secondary use substitutes for the original. Based on the foregoing, the use cannot be rendered as transformative and thus must have usurped multiple markets for the tattoos. They are separate factors. They can be separate. It's just they're not separate in this particular scenario, I don't think. Defendants contend that the fourth factor favors a finding of fair use because it has never sold merchandise and its use is transient and fleeting. But the court must respect plaintiff's economic choice. Furthermore, lack of involvement in one derivative market should not equate to no economic harm. In other words, they're saying that just because the tattoo artists don't release video games doesn't mean that they aren't harmed by a video game that uses their tattoos without paying them. Defendants fail to allege that their use is de minimis. I'm going to skip that one. That's pretty easy. They're saying that the tattoos only appear, on the player as they're running by on the screen, or maybe on the character creation screen, etc., and therefore isn't enough of an offense to amount to a copyright violation. I happen to agree that it is not a de minimis use, and that it is an offense whether or not it's a fair use, I'm also going to fall on the side that it is not a fair use. I kind of think that the tattoo artists have a really good argument on this one. I really don't understand why 2K would not have paid what I think amounted to an $819,000 annual license fee or a $1 million flat fee. It was like a $1.14 million flat fee. That makes almost no sense to me. Because NBA games, they sell these things every year. There's a whole bunch of people who buy them. There's no way that they don't have $1 million to pay to the tattoo artists to license their tattoos that they use in the game. But I can see the other side of it. To me, the argument isn't that they're reproducing the tattoo artist's work. I would actually make the argument that a tattoo might not carry a copyright for the tattoo artist. They're not showing the tattoo itself. They're not giving you a picture. They're not holding up a picture and saying, this, here's a tattoo. Do you want to place this tattoo on your character? They're showing the person how they appear in real life. So that's really, that's the only argument I hear or see, is that they're faithfully reproducing the person who has licensed themselves, and that person owns that tattoo. But do they own the right to reproduce the tattoo in video game likenesses of themselves? I don't know. I'm going to have to defer to a judge on that one, or lots more legal research, because if I put a tattoo on myself, I really feel like I own that tattoo. But if I didn't get an agreement with the tattoo artist that I own the copyright to that tattoo, who owns the copyright? Well, it's the author who creates it. And the author is the tattoo artist who created the image, because you trust me, these images get created first before they get tattooed. So I have no doubt that the author, the tattoo artist, has a copyright in the original image, but do they have a copyright in the image as reproduced on the person? I'm on the fence on this one. I am really on the fence on this one. Okay, so Lucas Spren brings up a good point here. If the tattoo artist did not come up with the original design, let's say that I have a piece of art that I want tattooed on my body that I own the art, or otherwise have the rights to that art, and then I have a tattoo artist fix that onto my body. Correct. They do not own the copyright, because they have simply reproduced that by license onto my body. Also, no, I will never be getting any tattoos, especially not after the recent finding or study that they find that people's lymph nodes contain the ink. The tattoo ink actually makes its way to your lymph nodes, and as much as everyone reassures me that tattoos are benign and do not hurt you, I'm just going to mess with my body as little as possible. No problem with people who have tattoos, like tattoos, feel good about their tattoos. I just don't personally have tattoos. What are you shuddering about, Lucas? Let me see. But yeah, so that's a really interesting case there. Is a tattoo, who owns the tattoo? Let's assume the tattoo artist made the tattoo design themselves. Does the tattoo artist own the copyright when they transfer the tattoo image onto your body? Now keep in mind that the wedding photographer owns the copyright to your wedding photographs that they take, unless you have an agreement to the contrary. And they usually charge a lot of money for that, extra money for that. So this sounds an awful lot like the photographer case, no? The tattoo artist creates a copyrighted tattoo, then you hire them to put it on their body. You might even commission them to create a drawing that you want to put on your body, but you commissioned it from them. They created it. That's a commissioned work, and unless you have a work-for-hire agreement, we've gone over this in the Imagos case, unless you have a work-for-hire agreement, then that tattoo belongs to the tattoo artist, and they are licensing it to you to put on your body, no? Whether or not you then have the right to sell your likeness, including that tattoo. See, I think you do have a right to sell your likeness. But that's just my gut feeling. I don't know why I can't articulate that. A photograph of you is not your body, but if a modeling agency goes to sell a photograph of me, and I licensed that photograph, but I have an unlicensed tattoo, no extra licensing on a tattoo on my body that was photographed, that photograph is being sold by a modeling agency. Does that mean that every time I get a tattoo, I have to make sure I get a proper license agreement for that tattoo so I can show it to my modeling agency so they can sell my photograph? Does this open up the floodgates to other tattoo artists who didn't know this before to now go and sue for everything within the past 3 years that's allegedly a copyright violation? I'm pretty sure, Kate, as well, that the artist still owns a copy of the original art and owns a copyright and can enforce that. But the modeling agency isn't photographing my tattoo and showing just my tattoo in this scenario. The modeling agency is photographing the beauty of my body, and the tattoo happens to be part of my body and part of the beauty of my body and part of my likeness. So are they reproducing your copyrighted tattoo, or are they reproducing my body? Oh, that is just a tough question. I really like this case. I really, really like this case. I don't know. I'm on the side of the tattoo artists. NBA 2K Games, Take-Two Interactive shouldn't profit from the tattoo artists' art without paying them. At the same time, if I'm a person who got a tattoo put on my body that I paid for, I really feel like you don't have the right to take down my photographs because I took photographs of me wearing my tattoo. What if I had a tattoo on my neck and you could see it, and I took a selfie and posted it on Twitter? Can a tattoo artist take that down because I didn't get permission to put that tattoo on my face on Twitter?
So I have a suggestion. Maybe what happens is when you purchase a tattoo, you gain the express license to use that tattoo in your own photographs and works, but the tattoo is protected from other tattoo artists using that tattoo and making it. And
right, so others couldn't reproduce the tattoo as a tattoo, but could others reproduce under license from the person you tattooed that person's likeness, including the tattoo? So
the question,
I'm starting to convince myself that it's actually Take-Two that's on the right side of this.
The question is it a transferable license?
And what are the circumstances under which it transfers or is implied or exists at all? That is a tough question. Yeah. Wow. Yes, Take-Two gets lots of money, and that's fine, but I have no problem with the fact that that's a commercial entity. It actually makes it more important that we get the adjudication of this right to me, because there's so much money involved. Oh, that's a tough one. I don't know where I fall.
Cuttlefish asked a good question. What if the person is in the game without the tattoo? Is that even still the person? Because a tattoo is a part of the person.
So yeah, like what's that then? If you want to reproduce a person's likeness, then if this case gets adjudicated in favor of the plaintiffs, in favor of the tattoo artists, does that mean that everybody's got to go remove the tattoos from their characters in games and either cover up or Photoshop out the tattoos that are on models who get photographed for magazines or other uses? I can understand. Now here it is. Maybe here's the line. when I go to sell stock photographs, I have to edit certain things out of my photographs or not include certain things in my photographs because you can't have a Coca-Cola can in the background, prominently in the background of a stock photograph, right? So maybe that's the line. Maybe the line is here, the way they're exploiting the work. If you're selling your photograph to a magazine as a reproduction of yourself, that's fine. You don't need permission. If you're selling an image of your arm with a tattoo on it as a stock photograph or for further commercial exploitation with the tattoo being the prominent thing, then that requires a license. So, still doesn't answer the question of where Take-Two and 2K Games are, because the purpose of the game is to play basketball, and the purpose of the character is to be authentic. So I get their argument that it's de minimis, that it's a fair use. And is it fleeting, though? Because I'm sure that the tattoo is prominently featured, as Solid Oak Plaintiff says. Even without playing the game, I'm sure that there's a character creation screen or something where you get to like spin your character around from 360 degrees and see up close the character's body. Because, you know, we do idolize our athletes. So there's no way they're going to not include a close-up of the guy's clothed body, including the tattoos that are visible. So is that then a commercial exploitation? Is the whole video game a commercial exploitation? I honestly don't know the answers to these questions. Yes, they are exploitations, but are they like infringements? So that's whew, good luck. I'm looking forward to the opinion on this one.
For sure.
I would expect amicus briefs on this one. I would definitely expect everyone, including other tattoo artists, to weigh in on this one.
It's a big issue.
If I was a judge on this one, I would just call it a tie.
Dismiss with prejudice for both parties.
No. What is a tie in this case? I don't even know. That's why we don't have ties.
Plaintiff is awarded $1,000. Defendant is awarded $1,000. Go home.
Yeah. I don't even know. Oh, yeah. I shouldn't have gotten up at 6 o'clock this morning. Okay, so let's take your questions from the whole stream. And then I want to close this down before 12 o'clock because I would like to get a chance to take a break before the 1 p.m. Patron stream. Basics of copyright for content creators.
I have about 10 questions here. Question from Daniel. Have you done any study into ethics? And what kind of ethics system do you think is the most interesting or aligns with your personal beliefs? Like Kantian or utilitarian ethics systems?
Oh, no, I haven't done any research into those ethics systems. I thought you were talking about, when I first heard ethics, I thought you were talking about my professional ethics. We have a code of professional responsibility set by our states. For me, it's the state of Pennsylvania. Plus, there's a general one that's just a good idea to stick to. Plus, there will be like local ones for the judges and things like that. But basically, our ethics code is that we have to be trustworthy. That lawyers are not allowed to lie, especially to their clients. That we have to be trustworthy with money. That we're not allowed to cast the profession in a terribly disfavorable light, or at least unmeritoriously disfavorable light. That we have to be honest to judges. That we can't use the legal process for illegal or unethical means. Stuff like that. But no, I have not subscribed to any particular category of ethics or classification of ethics. That would be 1.5 hours Tau. Yes, because we've been going for 1.5 hours already.
2 if you include the Patron stream.
2 hours we're going, yes. And 1.5 from now will be the basics of copyright.
Right, so if you guys want to Patron up, you guys can ask questions on that. We have the system set up. It looks good.
So my ethics are fairly well aligned with the basic ethics I'm going to say this out loud. Don't take this the wrong way. But the basic ethics of Jesus Christ in the Bible. I was raised a Christian boy, and I really, really like Jesus. I think he's a really cool guy. I think he had a very open mind. I think he visited Southern Asia and learned about Buddhism, and I think he brought that back, and his teachings are based on a more accepting and humanitarian view of the world. I think that his views are inconsistent with some of the other views in the Bible, and I honestly find the whole do unto others, be a good person, don't be corrupt, let everybody have a chance. I kind of find that all to be terribly wonderful, and so that's where I find my ethics to be based off of. However, I have since found my experience with religion to have been distasteful, and I have more or less consider myself an atheist or agnostic at this point, and my religious beliefs would be more so wonder at the awe of the universe, the mystery of where we came from, where we're going, and what our purpose is. Questions that really can't be answered by science yet. And I do incorporate science into the rest of those beliefs. So my religious beliefs as they stand now are that people like Jesus Christ are wonderful people who are examples to follow, and that religion should be, for me, the study of the universe coming to understand itself. We are sentient. Everyone around us is some level of sentience. We are all becoming conscious individually. We are all becoming conscious together. Can you imagine, as this just goes further and further and further, this consciousness becomes more and more universal, literally the universe becoming conscious. So I'm more pantheistic in that way. We are all part of God, if there's a God, and we are all God becoming conscious, becoming itself. Not a white man in the sky with a beard arguing over whether we've done things his way or not. So I am not trying to condemn anyone else's genuine meritorious religious beliefs, but I will condemn to the ends of the earth anyone's misuse of religion in order to further bigotry and hate and passing off of scientific thinking or progress or advancement of the human race, or to divide us, or to be discompassionate, etc. I don't find those things to be in line with the teachings of any of the major religions, and find that to be mostly a bastardization and a misuse of them. So that's where I stand on those things. Sorry for getting on my soapbox a little bit, but it's a very important topic to me. And it is Sunday morning, so it feels right.
Indeed.
Questions.
Next question from Crom regarding Campo Santo taking down PewDiePie's video. Is an implied license revocable?
Yes. So it is true that Campo Santo can revoke that license. And they can revoke it individually. So they could revoke it as to me if they wanted to. However, we do have something embodied in our Constitution that does apply to everyone called due process. And although the most useful meanings of that term are in criminal law, it does apply to civil law as well. So if you have an implied license and you are operating, if you are relying on that implied license, the opposing person or the person who is revoking that license needs to notify you and give you a meaningful opportunity to respond to that license. That is literally the definition of due process. Notice and a meaningful opportunity to respond. So in my humble opinion, Campo Santo, Sean Vanneman, and the Firewatch DMCA, while it may have been allowed, while he may have been able to issue a DMCA, what he should have done, and the proper procedure would have been to notify PewDiePie, allow PewDiePie a reasonable chance to take down his video, and we can argue over what reasonable means, whether it means an hour or a day or 30 days or 30 seconds, I get that. But that there should have been some chance for PewDiePie to respond and say, okay, I'll take my video down, or no, I won't. And then if he did not take it down and they still feel that they have a copyright violation going on, I guess I could see the argument that they would if they've revoked his license and he's refused. Then take it down with a DMCA takedown notice. I don't think what they did was proper, but I also don't think that PewDiePie is going to fight it in any way. As long as he doesn't fight it, the strike will come off his account anyway, and as long as this is only his first strike, or his first of this round of strikes now, then there's no consequences to his channel, no major consequences to his channel. Maybe a little bit of demonetization, I don't know, but he's got that under control. So I'm not worried about him suffering too much from this. I'm not even terribly worried about Camposanto suffering too much from this, although even I went to the Firewatch Steam page and changed my review from positive to negative and said that I disapproved of this use of the DMCA, especially without notice and an opportunity to respond. But I also explained that that's because I'm a copyright attorney and this feels like you're misusing the thing that I fight for. So that's my own personal bias. But then again, honestly, if Camposanto didn't want to be drug into it, all they had to do was not drag themselves into it. So they weren't part of it to begin with. So all they had to do was not make themselves a big part of it.
Yeah, they certainly involved themselves in the issue.
So I personally, I'm not calling for any boycott or anything like that. I personally have decided that I will not purchase any more games made by Camposanto, or if Panic doesn't distribute other titles, that I'm not going to be buying any more Panic titles either. That's not a big deal for me. Firewatch was an interactive story. It was kind of cool, but no big loss for me. I honestly don't have enough time to play the games that I've got now, so it's going to be easy for me to pick and choose. And so Camposanto won't make $14 off of me for a $20 game in the future. Okay. Oh well. I'm done with that. So that's it on that one. Questions?
Alrighty, Leon asks, can YouTube's safe harbor continue now that it has an AI that can check the content of every video? I paraphrased a little bit.
It's open to challenge, sure. If something has changed, then YouTube could be challenged again. I have a feeling that they're only getting better at maintaining their safe harbor, not worse. So, you're going to need some major resources to challenge that one. That's not going to be a simple file something in court and you win. You're going to need Google-level legal department to challenge that one, I think. So you'd better have a really clear win on that one, I think, before you file that lawsuit. I'm not making fun of you. I'm simply saying that that Google and YouTube are well known for narrowly tailoring their services so that they do fit in the safe harbor. They have been challenged and they have won before, so you have a very, very much uphill battle if you're going to challenge Google on their safe harbor.
Yeah. Gareth asks, have you been contacted by H3H3 to do a collaboration?
I have not been contacted by H3H3. Consider that my canary.
Is there an update on the Harmony Gold versus Tatsunoko lawsuit by Zex Maxwell?
Sort of. It's a non-update. The update is that the arbitration award was confirmed. So everything we talked about in that arbitration award, I believe that whole thing was confirmed. And because it's confirmed by a judge, that means it's now enforceable. And enforceable means that in 2021, Harmony Gold does lose their license. So I haven't heard whether there have been any statements from Tatsunoko or Harmony Gold on how that's going to play out in 2021, but if there's some kind of dispute with Battletech and them after 2021, it becomes Tatsunoko who gets to have that dispute instead of Harmony Gold. And that's really the only update that I have on that I know of.
Alrighty. John Rogers asks, a candidate for mayor in Albuquerque intends to legalize marijuana in this city and claims that it would be legal until the courts figure out if he can legalize it separately from the state.
One more time, you cut out there in the middle.
About that. A candidate for mayor in Albuquerque intends to legalize marijuana in the city and claims that it would be legal until the courts figure out if he can legalize it separately from the state. So the question is...
Okay, so if I did that, if a private citizen did that, of course, they can be charged with a crime, but could a city official, by passing a law through the proper channels, then have a state judge turn around and say, oh, no, you can't do that? In that intervening time, what happens? You could. You've seen this before. You saw this with the marriage equality movement a couple years ago. You saw Karen somebody? Was her name Karen? I forget her name. She's completely forgettable to me. But you saw that one Kentucky clerk? Oh, this is how much I've forgotten about this. The clerk in Kentucky refused to issue marriage licenses to people who were getting married under the under the newly recognized right for homosexuals to marry. I'm trying to choose my words here because this is very important to me. I do not consider marriage to be different between a man and a woman and homosexual partners. I consider it to be marriage. And so I don't want to say gay marriage. It is marriage. So I'm trying to call it the marriage equality movement. That's what I'm trying to get through here. I'm not doing this because I'm afraid of backlash. I'm doing this because this is what I believe in. So this person refused to issue marriage licenses, and I think even a couple states tried stuff, or a judge even tried stuff, because this happened in more than one place, where they tried to make it illegal to issue marriage licenses to homosexual couples, under the guise that because it was the government doing it, that it would be harder to prosecute individuals. But they did anyway. The clerk was given a court order, then the clerk disobeyed the court order, then the clerk was thrown in jail, right? Karen Davis? Kim Davis. Kim Davis. Yes, thank you. It's eerily close to my ex's name. I think that's why I tried to forget that. Anyway, so the point is, maybe this mayor is doing this because he thinks that it will send a message while also insulating him from criminal prosecution. But I think it would only insulate him from criminal prosecution until that first court order was issued, and that can happen very, very, very quickly. It can happen any time. There are emergency numbers. You know, the public doesn't know them, but if I call one of the emergency numbers at the courthouse and the emergency person thinks that I really do have an emergency, they can get a judge out of bed in the middle of the night to adjudicate something that needs to be adjudicated right now. The most common thing this is for domestic protection from abuse orders. When someone has a domestic violence problem in the middle of the night or on a weekend or something, you can get a PFA from a magistrate judge at any time, but you have to go through the police. The police have those numbers. They don't give the public those numbers. Thank you, Ian, for the $2, and thank you, other person, for the $5. Johnny Rogers, appreciate you both. So it's probably not going to stay legal. It's probably more of a political statement that's being made by doing that. Even at this point, I can't shy away from making public statements that marijuana is nowhere near as dangerous as harder drugs. And it's basically, to me, not even as dangerous as alcohol from what I've seen of it. And I'm not sure why our government continues to insist on prosecuting people for... It's basically a long-term alcohol prohibition. And you saw how that worked out. There were gangsters and organized crime and murders and things. And, you know, we've had this war on drugs, which was sort of to answer the criminal element that rose up as a result of a black market on drugs. And now you have people who are in jail for life and all they've done is possess marijuana. That's kind of ridiculous. I would have to hear that those people are somehow worthy of staying in jail their entire lives and it's worthy of our taxpayer dollars, etc. It is possible the state could look the other way on the city marijuana legalization issue. That's possible. You don't know unless you try, right? Multiple counts of possession. Yes, right. So my point isn't that everybody should go get high. I don't believe that everybody should be intoxicated 24 hours a day either. I mean, come on, this is a bit hyperbolic in both directions if we go there, right? So, but it is a bit hyperbolic to say that there are no medical uses and that there's no research to be done, even by professionals in a controlled environment. And I just don't understand that. The people that I have known who have used it, they're not bad people. They never were bad people. They didn't become bad people. So why are we creating this self-fulfilling prophecy that we're going to tell you it's bad, and then if you use it in disobedience of us telling you it's bad, we're going to lock you up to confirm that it's bad? That's a self-fulfilling prophecy and not in any way related to the actual natural consequences. Sure, lock people up who drive while intoxicated. Lock people up who abuse people while intoxicated. Lock people up who don't follow the regulations or don't pay the taxes or whatever. Maybe not even that last one. I don't quite agree with locking people up for not having money, but I do agree with locking people up for having money and not paying taxes. Thank you for the Swedish 20 kroner. Almost forgot the Nordic money fight today. So far, you're the winner. We could start a bidding war again. I'm happy to have that. You guys gave me a couple $100 last month. That really helped. Can't deny that. I'm looking forward to the 21st on September 21st or so when I get my nice little paycheck from all of your donations. I agree it smells better than tobacco, but that's getting much too close to revealing my personal knowledge, so let's not go there.
Kira asks,
it is still illegal, and you should understand that if you break the law, you could be punished. And that's a hold off just for a second, Brandon. That's a really interesting point. We do have something called prosecutorial discretion in this country, and I call it the law of committing one crime at a time sometimes as well. Not the same, but they correlate. Basically, don't commit crimes if you don't want to get on somebody's radar. If you don't drive a car that's out of inspection or out of registration or broken taillight, then the cop can't say I pulled you over for a broken taillight, at least, and get away with it, or charge you with registration or something. So then the secondary of that is if you don't commit the first crime, then you won't get caught for the second crime. So only commit one crime at a time. If you're transporting something illegal in your car, don't have an invalid registration, etc. I'm not advocating that people do illegal things, but these minor infractions are the thing that leads to more major infractions when people are already committing crimes. It's just stupid to be smoking marijuana and driving, which is a pretty easy thing to catch if the person is terribly intoxicated, and then you are committing multiple crimes. You are putting yourself within a prosecutor's discretion. If you commit the minimum number of crimes to support your drug habit or whatever, then you're in the minimum of the prosecutor's discretion, and therefore you have the minimum chance of getting caught. So I don't recommend that you commit crimes, but I also recognize that you almost can't go an entire 24 hours, no one can, without committing some kind of offense. Yesterday, I drove across the white line that was between, a solid white line that was between two lanes of traffic. There wasn't any traffic. It was perfectly safe. But it's an offense, and if a cop wanted to pull me over, he could pull me over for crossing that solid white line. So, if I'm drunk and I cross the solid white line, well, guess what? He pulled me over for crossing the solid white line, and now I'm gonna get hit for drunk driving. I'm, again, not advocating drunk driving. Actually, quite the opposite. My father was severely injured by a drunk driver. My life was severely affected by a drunk driver. And I honestly would punch any drunk driver I found in the face without hesitation. So don't think that I'm advocating that anyone drives intoxicated. I'm just saying from the lawyer's perspective, you don't want to mark yourself as a target for prosecution. And so if you are going to smoke marijuana in disobedience of the law, do it in a way that minimizes that in view of the prosecutor. Don't do it in public. Don't do it in your car. Don't transport it as much as you possibly can, etc., 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 because all of those things put you within the purview and prosecution discretion of the prosecutor. That can be the cop, that can be the prosecutor, the DA, that can be a U.S. attorney, or in your country it'll be called something different. So, again, not advocating that anyone commit any crimes, but it's, again, sometimes hard not to when you're just a human who does make mistakes in things, and even mistakes can lead to a criminal prosecution. I'll be happy to face 5 a drunk driver. I've taken several drunk drivers off the road just by cautiously following them and continuing to call to police, describing their behavior, and explaining that I'm not going to stop calling the police until they're pulled over.
I was gonna say you should have waited for the statute of limitations on that offense yesterday.
Yeah, I'm not worried about it. I admitted on stream that I crossed a solid white line. I don't know that that's enough. I didn't admit where. I didn't say where. They won't know which jurisdiction to charge me in.
Federally charged for crossing a white line.
Oh, my take on the Martin Scully situation. You know, it's funny. There have been a few douchebags in American history who couldn't get charged with the offense that they really, really committed. The big social offense that everybody knew they were committing. So, for instance, Al Capone. Everybody knew Al Capone was behind alcohol smuggling. Everybody knew he was behind a huge organized crime gang, but they just couldn't prove it in a court of law until they got him on tax evasion. So they didn't prove Martin Scully is a scumbag who increases cancer meds or whatever by thousands of percentage points in some unethical way. That's not technically illegal, and he didn't technically violate any law, right? I kind of hate that, but they certainly did find some other thing to get on him, didn't they? So, if you believe in karma, I believe this could be your confirmation that karma exists. And that karma would be in the form of US prosecutors who noticed how much of a scumbag he was and followed his activities enough to find something to nab him on. And then, of course, prosecute it all the way through to the point that he gets jail time. And then, because he's just not a big enough idiot, he goes and asks the world to get him a lock or a sample of Hillary Clinton's hair. What? I mean, okay, like that'd be cool. Like, I want Barack Obama's autograph. Okay, how do you get Barack Obama's autograph? You go to a book signing and stand in line. How do you get a piece of Hillary Clinton's hair? You don't. You have to go and, like, grab her and cut a piece of her hair off. You have to assault her. So I'm with the judge. The judge said that. It's like, you're encouraging people to go and try and get a lock of Hillary Clinton's hair in some illegal way. And that has got to be some kind of scary prospect. Not something that we expect a convicted felon out on bail to be doing. So she revoked his bail and threw him in jail, I believe. And I don't know where it's gone from there, whether he successfully got back out on bail or whether he's just going to be in there till he serves his time. But yay, Martin Scully got locked up, finally. Yes, I love the way you look at me. You look at me like you love me so much. And you look at me like you hope for pets. And more food. And maybe that we'll go play outside. Okay, it is 11:59. I am going to take an hour break, and I'll see the patrons back here in an hour. I first want to thank my $50 plus supporters, Joshua Mindseeker, John Steele, John Cripps, Nate Beck, Lydia Collinson, and Weston Loney for your support in the month of September, and to New Sensei for his support, $500 in the month of August, supporting the patrons stream that I'm about to do, on the basics of copyright for content creators. I'm also going to go eat lunch, as my stomach is now telling me that I am not well. Anyway, so thank you all for watching, and I will see you back here in approximately an hour for the live shooting of the basics of copyright for YouTube creators or content creators. So thank you all very much for joining me. You can feel free to submit more questions to Brandon. We'll put them on the list. I definitely try to answer the good questions, and especially the questions that I have not answered before. So again, thank you all, and I'll see you in about an hour, patrons. I'm Leonard French, your favorite copyright attorney, and you guys have a great week. I love you all, and I'll see you later. And I will figure out how to stop the stream here in a second. There we go.